सब्सक्राइब कीजिए एसपी एजुकेशन चैनल को और बेल आइकन पे क्लिक कीजिए सबसे पहले हमारे वीडियोस को देखने के लिए।
Hello everyone, welcome to SP Education, and today in this video we will be discussing a very important topic, which is right to constitutional remedies. We were doing fundamental rights in our previous videos. Now in this video we will be discussing a very important fundamental right also. Now right to constitutional remedies is the fundamental right which is enshrined in Article 32 and Article 226 of the Indian Constitution. Article 32 contains the writ jurisdiction of the Supreme Court, and Article 226 contains the writ jurisdiction of the High Court. Now coming to right to constitutional remedies in detail, we first need to understand what is the meaning of writs. What is a writ? Now writ is actually and basically a direction, command or an order of a court which is a remedy against any injustice which is done by any governmental authority. Now writs are a kind of a remedy for an individual to claim in the court of law. So when any fundamental right is encroached by the state, then an individual can approach the High Court or the Supreme Court for the enforcement of these writs. These writs in turn will protect the fundamental rights or any other legal rights of the citizen who claims them in the court of law. Now Article 32 and Article 226 both provide for writs. Both provide for the writ jurisdiction of the courts. But what is the underlying difference between these two articles? Now Article 32 talks about the writ jurisdiction of the Supreme Court, and Article 226 talks about the writ jurisdiction of the High Court. Now there is a mild difference between these two articles, and that is the basis of the distinction between these two articles. Now Article 32 says the writ jurisdiction of the Supreme Court. Now we need to understand that the writ jurisdiction under Article 32 of the Supreme Court is actually narrower than the Article 226 writ jurisdiction of the High Court. Why it is narrower in scope is that under Article 32 a citizen can approach the Supreme Court for the protection and enforcement of his fundamental rights only, whereas if we consider Article 226, the writ jurisdiction of the High Court is wider than Article 32, which says about the Supreme Court's writ jurisdiction. How and why it is wider than Article 32? The reason being is that the High Courts have the power and authority and the competence, in best words, to issue writs for the enforcement of fundamental rights as well as for the enforcement of other legal rights also. For example, any legal right of any person is infringed, then he can approach the High Court for the issuance of writs. But if only a fundamental right of a citizen is infringed, fundamental rights are the rights which are contained in Part 3 of the Constitution, and any other right apart from fundamental rights, which is a legal right also, is infringed, then the person can approach Article 226, can go to the High Court under Article 226 of the Constitution of India. So thus there is a question that is always asked to any student preparing for a competitive exam where constitution or polity is a part of the syllabus, that Article 32 is wider in scope than Article 226 or Article 226 is wider in scope than Article 32, then you always have to remember that Article 32 is narrower in scope than Article 226 for the sole and the only reason that under Article 32 one can approach the Supreme Court for the protection of fundamental rights only, but under Article 226 of the High Court the person can approach the High Court for the enforcement and protection of fundamental rights as well as the legal rights also. So continuing the topic of right to constitutional remedies, let us understand what is the meaning of a remedy. Now remedy means something which is a solution to a problem. Now a solution to a problem, now the problem here before us is the infringement of the fundamental rights, the encroachment of the fundamental rights. Now the encroachment of the fundamental rights anywhere for any citizen which are given in Part 3 of the Constitution can be solved, can be provided a remedy with under Article 32 and Article 226. Article 32 and Article 226, both of them provide for the protection of fundamental rights. The sole difference being that one is under the domain of High Court and the other is under the domain of the Supreme Court. Now we have understood the basic meaning of writs. Now we also have understood the basic meaning of remedy. So writs are of various kinds. So the various kinds of writs we will be discussing in the next video, but here we need to understand what is the meaning of constitutional remedies. Also, one more question that people come across in their examinations is that whether right to constitutional remedy is a fundamental right in itself. That means, is Article 32 a fundamental right in itself? So the answer to this very important question is yes, the Article 32 is in itself a fundamental right in itself. Means that although Article 32 guarantees the protection of the fundamental rights, yet it is in itself a fundamental right. That means the right to approach the law court, the right to approach the Supreme Court under Article 32 for the protection of fundamental right is in itself a fundamental right. That means Article 32 is available to all the citizens of the country for the protection of their fundamental rights. Since we have fundamental rights in part 3 and Article 32 also falls in that part, we need to understand in very simple logic that Article 32 in itself is a fundamental right. So two things that have come across from the examination point of view here are that Article 32 is in itself a fundamental right. That means right to constitutional remedies is in itself a fundamental right. Also, Article 32, the writ jurisdiction of the Supreme Court is narrower than Article 226, which is the writ jurisdiction of the High Court. Now, coming to the next point is we need to understand that what are the various writs. Now, various writs are habeas corpus, mandamus, certiorari, prohibition, quo warranto, which are issued in different circumstances and cases. Before moving to these points in detail, let us consider what I have prepared for you in this PPT slide. Now we need to understand that there is a right in India which states that the person can move to the Supreme Court if she wants to get their fundamental rights. A right in India. So we need to first of all understand that right to constitutional remedies is a right in India. This is a right in India that states that a person can move to the Supreme Court. It means the person has one of the options, one of the remedies to approach the Supreme Court. For what? If they want the protection of their fundamental rights, if they want that their fundamental rights to be protected from any kind of encroachment by any state authority, governmental authority. Now also coming to the next line, it says this right comes under Article 32. The next point to remember and memorize is that this right comes under Article 32 for Supreme Court. If you want to approach the Supreme Court for protection of fundamental rights, you need to move under Article 32. The next line says, and Article 226 for the High Court, and Article 226 for the High Court. It is known as the right to constitutional remedies. Now till here we need to understand that Article 32 and Article 226 both are termed as right to constitutional remedies. This is the topic of this lecture today. Now in this right, the Supreme Court as well as the High Court, as well means both of them together, both of them concurrently, either of them can do the same work of protection of fundamental rights. It is the option of the individual, it is the option of the citizen, of the person to approach either of the two authorities to protect their fundamental rights. Now if they want to approach Supreme Court, they will move a writ petition under Article 32. If they if they desire to move to the High Court, they can move under Article 226, as simple as that. As the High Court is given the power to instill the fundamental rights. Instill means to protect in a deeper way. Furthermore, the power can be issued by local courts also to extend the rights. Now till here we have understood the very simple points that Article 32 and Article 226 is talking about. Now we need to understand that what is not covered under Article 32 and Article 226. What is not covered under Article 32 and 226? First of all, what is covered under Article 32? We have already discussed that there are various kinds of writs. The Supreme Court can issue writs. Under Article 226, High Court can issue writs. Now we come to a contrasting point here, which says that although there is one act which comes under the military law known as the court martial, which is exempted from this right, you need to understand that in constitutional law, There is a general provision and then there are exceptions to the general provisions. So one such exception to the right to constitutional remedies is that what is not covered under these remedies. So military law which is enforced by the court martial, the procedure is the court martial and the law is the military law. Now military laws are exempted under the article 32 and article 226. Okay, now another point of knowledge that you need to know for the examinations point of view is that article 32 is termed as the heart and soul of the constitution. Now B.R. Ambedkar, Dr. Bhimrao Ambedkar termed article 32 as the heart and soul of the constitution. In our earlier videos we have discussed that constitution is a living document. Now living document means that it breathes, that it changes, that it grows, that it evolves each and every day like any other person. Now when a constitution is ever evolving, it is ever changing, it is dynamic, it is not static, then it means that it is a living document. So for any living document or for any life, the essence of heart and soul is important, and according to Bhimrao Ambedkar, that heart and soul is incorporated under article 32 of the Constitution of India. So Dr. Bhimrao Ambedkar said that article 32 is the heart and soul of the Constitution, and it is at the very heart of it. Also the Supreme Court has included this in its basic structure doctrine. Now coming to this term basic structure of the doctrine, so we have discussed the meaning of basic structure of the doctrine in one of our earlier videos. Now basic structure doctrine means that some things in the constitution are so basic to the structure of the constitution that it is impossible to amend or change them completely. Although there are some things that can be changed and amended completely, but what is basic to our constitution can never be amended. So article 32 first of all is the heart and soul of the constitution. Why? The answer I have already given. Now coming to the basic structure doctrine, that since it is the heart and soul of the constitution, it is but obvious that it forms a part of the basic structure of the doctrine. Now Supreme Court has clearly declared, has categorically declared that article 32 is part of the basic structure of the doctrine of our constitution. Now furthermore, this right states that the right to move to the highest court cannot be rejected by any court except provided by the Constitution of India. Now if someone has to not apply to these remedies, I mean if someone has to be restricted to approach the Supreme Court and the High Courts, the highest courts of authority in India, then that procedure can only be done by the constitutional provisions only. Otherwise there is no point, there is no way you can stop anybody to approach to claim their constitutional remedies. Now we come to the next paragraph. It means that this right is suspended at the time of national emergency under article 359. Now which is the constitutional provisions? What are the provisions in the constitution itself that will restrict an individual from approaching these articles to protect their fundamental rights? So the provisions in the constitution that will restrict, that will stop a person from approaching the courts, high courts and the Supreme Courts for the protection of their fundamental rights are the provisions of emergency in the constitution, the time when everything is suspended, when all the fundamental rights are suspended except two fundamental rights. Now when we deal with the topic of emergency in detail, we will go into that. For the time being, we need to understand that during emergency, even the writ jurisdiction and the power to approach for the protection of fundamental rights to the Supreme Court and the High Court is restricted and suspended at the time of national emergency under article 359. So under article 32 of Supreme Court acts as a guarantor and defender of the fundamental rights. You need to understand that article 32 Supreme Court here in article 32 acts as a defender. Defender means someone who is protecting the fundamental rights. Furthermore, it is originally under the Supreme Court's jurisdiction's power to issue the writs. To issue the writs is under the Supreme Court's jurisdiction. Now we have been using this word writ jurisdiction many a times in our video now. There is one more thing that you need to note, that the concept of writs has been incorporated and is inspired from Britain, where the king and the queen used to issue prerogative writs. Now also, but the writ jurisdiction in India is much wider than the prerogative writs issued at the time of king and queen in Britain. Now, thus it means that a person can directly approach the Supreme Court for the remedy instead through the way of appealing. Now we need to understand that Supreme Court and High Court are originally courts of appeal. They are originally the courts of appeal. They have the jurisdiction generally to hear the appeals coming from the lower courts. Supreme Court has the power to hear the appeals coming from the High Courts, and the High Courts have the power to hear the appeals coming from the lower courts. Now this is what we need to understand, that Supreme Court and High Courts are courts of appeal, but when it comes to having the power and jurisdiction to issue writs, they become courts of original jurisdiction. That means there is no way that you come through appeals. You can directly approach them and they will all obviously take your matter of writs as a court of original jurisdiction. Original jurisdiction means the case first time comes to them. The petition is first at the first instance coming to the Supreme Court, and they can competently deal with it. They have jurisdiction, no one can restrict them. So when they are acting as a court of writ jurisdiction, when they are exercising the authority of issuing writs, the Supreme Court and the High Courts change their form as a court of appeal and they become courts of original jurisdiction. That is the essence of these two lines given below. So this is what we need to understand in the topic of writs. In the next videos, in the next week, we will understand the meaning of each and every writ. I hope this lecture helps you in understanding the concept clearly. Thank you so much and keep watching our videos, and if you have not subscribed it, please subscribe it soon so that you have more knowledge for your exams. Thank you so much.